Franklin Nolan, September 7th, 2015. Construction contract. To set the basis, I'm a board certified construction contract verifier, just about lawyer. And I want to cover basics and what type of representation of clients that are represented from just about any phase of contract, construction, design and build contractors, tradesmen, subcontractors, material suppliers, ranging from a very small residential renovation all the way to large multi-million-dollar commercial or even public projects. So our range experience is very vast and very diverse amongst our group, and I'm excited to speak about construction contracts, particularly considering in the past few years hasn't been that much transactional work by way of contracting, and there's a lot of litigating on the back end. I'm writing my first subcontracts through an AIA revisions, and it's been a couple years, so I began a couple years ago writing them. The 2012 to 2013 timeframe. Everyone knows that those construction opportunities weren't there. Commencing new work, and I've decided to get back into contract law, and I think it's something that we do well. It's at the core of any construction contractor's understanding by which you are going to put into any party's deal. You may have to unwind in the event that there's a dispute. So should you wish to learn a little bit more about this practice and my qualifications, feel free to seek further information on this page and look up my credentials, my profile, my construction practice. I'm going to move into construction contracts. Construction contracts can take many different forms, whether it be a written contract, whether it be a oral contract, whether it be a quasi-contract or contracts applied in fact in law. Many different varieties of construction contracts, very different in a technical nature from a regular contract, but fundamentally a contract is a contract. So at its root, construction contracts are construed and interpreted in accordance with contract law, whatever law may be for the governing jurisdiction. Most often seen contracts, I'll go over the AIA documents, but there's a general construction agreement, there's a subcontract, there's various types of materials that are supplied on credit applications, typically on an open account basis. So something as complex as a large lump sum contract with a 201, with a 15-page 201 and addendum, or it could be as simple as a material supplier supplying lumber or plants on a 2-page credit application. So I'll focus on the more meaty portion of the contract, the AIA documents, and some regular clauses that go with those type of agreements. Hopefully I'll be able to mention some practice pointers that identify some potential pitfalls, such that when you're putting such contracts or when you're litigating them, some things to look for in enforceability. Regards to the AIA forms, there's a few common forms that most any contractor should know. The 101 is the most widely used, with the short form 201 supplement. In this 101, it's a lump sum contract, so it's really a clear definition of the scope of work in order to have good flat fee arrangement. When you're putting together a 101 on a term on a lump sum type contract, it's a key to define quantity, quality, and time. You need to know when contingency are not included in the price, how to deal with, for instance, cost increases, concealed project conditions. You need to know whether the contractor warrants the plans and the site commissions. There's a lot in the 101 that you could probably need to be aware of, and you need to know. I would encourage you to review those standard formal agreements as your baseline once you gain your construction contract knowledge. Well, the 102, on the other hand, takes a lot of the risk out of it. That's a cost plus with a GMP guaranteed maximum price. One of the keys to the 102 is to clearly define what compensable costs are and what the fee structure is. Compensable costs, if they're not clearly defined, as you can imagine, there's some wiggle room in there as to how far the project, what the contractor can spend the money on the project. Of course, the year's incentive compensation is based on a percentage of what costs to drive up those costs. And so it's important to define clearly what's compensable costs are. And then conversely, what's the penalties of cost overruns? What do you have to, what does the contractor have to submit to the owner? Is there any independent intermediary language that certifies this cost? What documentation is required to approve costs? What do you need to supplement by way of pay applications, etc.? One of the issues that arises in cost plus contracts is sometimes can be more owners can be more inclined to interfere with the contract at that point because cost basis has them wanting to procure cheaper subcontractors and substituting them with another contractor procured into cheaper subcontractors. You want to think about those issues when you're thinking about AIAs, or as you get into AIAs, once you get into cost plus and GMP. With respect to a 201s, it's your Euro meat potatoes of the contract. That's your general conditions of the contract. It's the most used AIA document, and that's where you really import your project-specific type of clauses that go into truly govern a lot of the day in and day out operations of the project. So before we got into basic contract clauses, I think it's important to touch on project delivery methods in a concept basis. And I'm setting forth some project delivery methods, and we're going to focus initially on the design, bid, build, and the design, build delivery method. There are some other delivery methods of doing administrative construction projects that you probably need to be aware of if you are going to be involved in a construction contracting, and I've listed those on this page. I'm not necessarily going to focus on, but I'm going to go down the list of the CM, construction manager type of agreement, the at-risk or not at risk. There's multiple primary arrangements that can be contracted around integrated project delivery methods, and a real vote of topic these days is public-private partnerships. Public-private partnerships are something, I don't know if it's particular history, but I know the economic downturn that recently it became a very occurrent in the sense that public funds were strapped and the construction was hurting, and the government has wanted more skin in the game from the private practitioners. And there's various terms that, depending on the type of agreement, that a P3 can actually vary shapes that it can take, but it is a way of delivering goods and services and materials, and a way that buildings at sites that are being developed these days, what it means is something that probably you'll need to know as a practitioner. I'm going to focus on the design bid build method first because it's the classic, most used project delivery method. There's three main sequences, that phases of design bid build of the delivery method. There's the design phase, there's the bidding or the tender phase, and then naturally there's the construction phase. And under the design bid build phase, the owner typically contracts directly with the architect. I'm sorry, under the design bid build, the owner usually gets to go with the owner for the design first. The design documents are then provided to the contractors for bidding, and then the owner contracts directly with the contractor then. Typically, under this model, it's for a fixed price, and there's a lot of contract administration that needs to be dealt with and ironed out in the contracting phase, but it's what you think of when you think of a construction project. Design professionals makes the drawings, bids it out, gets the GC in place. GC puts the plan together or puts the project together by virtue of mostly of utilization of said contractors, and the GDC performs the owners, incorporating the work of the subs. So breaking it down a little further on the design bid build model, the design phase, in that phase, the owner retains the architect or the consulting engineer for infrastructure, however it works. The design produces the bid documents, including the construction drawings, the technical specs, and which the various contractors will in turn bid to construct the project. For building projects, architects will work with the owner to develop the needs, to develop the vision, they develop a written program developing those needs, and then produce a conceptual schematic design. Their early design at that point is then the architect will generally bring in other design professionals such as a mechanical, electrical, and plumbing engineers, fire protection engineer, structural engineer, sometimes even a civil engineer, and often a landscape architect to help complete the construction drawing and the technical specifications. The finished documents, bid documents that is, after those design works are made, they're coordinated by the architect, the owner, for issuance to the general contractors doing the bidding phase. The design fees are typically between 10 and 5 to 10% of the total project cost, but that may vary. The design bid build model, the bidding phase is then open. It can open with any qualified bidder. The qualifications are set by the owner and the architect, or it can be select, in which a number of pre-selected contractors are exclusively invited to participate in the bid. The various general contractors bidding on the contracts obtained various bids. They put it out to multiple subs for bids on the subcomponents of the project. The subcomponents may include the consulting components mentioned, as well as beyond, such as concrete work, structural steel frames, electrical, HVAC, plumbing, etc. Bids are then based on quantities of materials, the operations need to build, or simply lump sum cross. However, the bids are within the confines of the bid documents. The public works, obviously there's a lot of specificity that's required in the procurement of context, and I think that's really the bidding process in public works. It's really beyond what I'm talking about. With your respective state statutes, you want to know what's exactly involved in your government's procurement and the timeliness in which you send your RFPs out, and in which your reverse responses to your RFPs, and exactly how you become a qualified bidder. Once the bids are received, the architect typically reviews the bids, seeks any other clarification that might be needed, investigates qualifications, and makes sure the documentation is ordered, and makes sure the bonding if necessary, and advises the order as the advising of the bids. The bids fall within an acceptable range. The owner then discusses the suitability of various bidders and the proposals. The owner is not owner to accept the lowest bid, and it's customary for other factors such as past performance, reputation, and the industry, qualities of other work, etc., are utilized in the selection process. However, projects typically awarded to the general contractor with the lowest bid, that is a qualified bidder. In the event that the bids do not satisfy the needs of the owner, whether for financial reasons or otherwise, the owner may choose to reject all the bids, at which time certain options become available to the owner. The owner could then rebid it or put it down for rebid, maybe on future date when the owner's needs are met, as such when more money is made available or the project costs go down. The materials tend to fluctuate in the construction industry as material costs tend to fluctuate, and that may at times, as well as labor forces in the construction world, and that may affect the ability to bid or may drive the cost down, as well as cash flow on the owner's side, as credit terms fluctuate with the lending capacities and restrictions. So do the ability for the owner to run projects which they could finance. So again, if the bids are not in conformity or rejected, the owner can re-vet at a certain time, abandon the project altogether, or perhaps issue a work order or have the architect to re-advise the design. Sometimes, if it's in the contract with the owner, that may have no cost. If that's in the contract with the architect, if it's previously negotiated. But the idea is revise the contract or revise the bid solicitations so as to make the project smaller, more efficient, reducing elements of the project to bring the cost down, and reissue the bid tenders. Or there's an option where the owner may select a general contractor, such as the lowest bidder or an experienced cost estimator, to assist the architect in design changes and cost reduction. This process is often known as valued engineering. So the bids may be altered to value engineer and then reissue. Now, the construction phase of the bid build process. Once it's been awarded to the contractor, the bid documents, again, prove drawings, the technical specifications, they may not be altered. Should design changes be necessary, whether initiated by the contractor or owner or discovered by the architect may write you sketches or direct clarification, but the contractor really has as-built building requirements. In most instances, nearly every component of a project is supplied and is sold by subcontractors. The general contractor may provide work with his own forces, but it's common for a GC to limit its role to permanently managing the process and daily activity on the construction project. During the construction phase, the architect also acts as the owner's agent as it relates to pay requests of the contract from the contractor, to issue site instructions, change orders, or field orders, with their documentation necessary to facilitate the construction process, and certify that the project is built in pre-approved constructive and approved drawings. Like any other project delivery methods, there's pros and cons to this, and I'll mention briefly about the cons, and I'm going to go through the pros. So the cons in the bid build process are the design flaws that can really cause project delays. If The construction documents need to be redone to reduce costs. Also, this method can develop a cheaper is better type of mentality amongst the general contractors bidding the project. So there's a tendency to solicit the lowest cost subcontractors in a given market. In straw, sometimes the GCs can be select. In strong times, the GCs will be easy to find, but low times, the lower bidder usually results in a increased risk from the general contractor, which certainly compromises the endurability of the construction. As a general contractor is brought in to the team post-design, there's really little opportunity of the effective alternatives being presented, and the effective alternatives affected. The design phase is already completed. No contractor has to build a design if there's an inherent design flaw. This delivery method doesn't necessarily afford the contractor to have that hands-on technical expertise and input that may otherwise afforded. Of course, there's the pros that I've talked about. The design team is partial and looks out for the design interests of the owner. The architect, remember, the architect looks out for the interests of the owner. The architect is able to be the intermediary between the contractor and be the guidepost to ensure that the project stays on task in accordance with the design. When there's the design build process, whereas the contractor and the architect are essentially the same unit, that layer of separation doesn't exist, and sometimes there's little inherent conflict of interest that arise and make it challenging for the owner-contractor interactions. The design, the pros to the design bid build process are also the design team provides documents on which all general contractors prepare the bids. So with this in mind, the cheaper is better argument kind of is rendered invalid since the bids are based on complete documents. Incomplete, incorrect, or missed items are usually discovered in the bid build process in the form of addenda. So I don't think it necessarily always carte blanche provides a lower bidders cheaper mentality. I think that this method also ensures fairness to potential bidders and improves the decision making by the owner by providing a range of potential options. It creates a competitive marketplace, which I think that everyone tends to benefit from. It assists the owner establishing reasonable prices. It uses the competition component of the bid selection process for the contractor to improve the qualities for the owner. It has an understanding of the roles of each party and the construction process. This is why we're walking through these delivery methods. So as we get into different terms of contracts, you'll be able to understand exactly how it's administered, who has to, and what has the obligation, what is the additional considerations. I'm going to touch on to design build. Design build is a delivery method used in construction industry. It's a method to deliver projects which the design construction services the contracted by a single entity or design builder or design build contractor. In contrast, we just walk through a design bid build where there's an owner contractor, owner architect, and contractor. The design build relies on a single point of responsibility for the contract. It is designed to minimize risk to the project owner and reduce the delivery schedule by overlapping the design phase with the construction phase of the project. The design builder, with his single point of responsibility, carries very clear contractual remedies and responsibilities for the clients or the owner, because the design builder contractor will be responsible for all the work on the project regardless of the nature of the fault. The design build procurement changes the traditional secrets of work. It answers the client's wishes for typically a source of responsibility and an attempt to reduce overall risks and project costs. I sense that this is really becoming a preferred project delivery method for major projects. I would say that around 40% of non-residential construction projects are design bid build projects, which is about 10% increase from the previous decade. So whether to increase at that rate, I'm not sure, but I know that this in-house design bid build component, especially on large commercial projects, is really the way to go, because the owners get the white glove service that they're used to, and everything's all controlled and buttoned up in one contract. With that said, there are cons in this. Certainly cons for contractors is more liability, have to have a more vast staff and more capabilities. It creates powerhouse firms and less of the tradesmen, so to speak. So the smaller construction companies, smaller GC types, and in the construction world, I don't know that that is best for the competitive nature of the construction world. I also think that it creates an interesting insurance and bonding predicaments in situations such that to be a design builder, you really have to have substantial financial capacity, and I do think that it's cost efficient to have good business. And another con is to invoke the competitive bidding process, in which you have prospective bidders bid on the same design, so you're not getting that market efficiency. Sometimes for owners, the criteria is subjective, and to select a contractor is subjective, and it's difficult to evaluate, justify later when you're dealing with a design bid situation. When, for better or for worse, for true or for not, the design and price situation really arouses public suspicion in times when design builders are on public project. So moving through, hold on. I'm going to move on to key contract provisions and some things that need to be aware of when you're putting together agreements and when you're entry spotting. Scope of work and its importance. Interpretation of projects. What is the order of precedence? I'll mention the flow down of ordinance principles according to the subs and GCs. I'll mention payments, which is obviously a huge issue, and obviously change orders, liquidated damages, and delayed damages. Indemnification is a big one. Implication of additionally named insurance, noticing requirements, dispute resolutions, and attorney's fees, of course. Moving to my first point in the scope of work. A general contractor, for example, in the scope of work benefits from a vague scope of work provision in the subcontracts, but would want something very specific. The provisions in terms of its general contract, the subcontract necessarily will want a very specific scope of work in the subcontract. An owner would likely have terms of the general contractor's words to be vague and inclusive as possible. Why? Because of liability. That's the reason. Scope of work is the basis of the contract. As such, it establishes the rights and the responsibility of the parties, what is expected and what's promised. It's the most basic and important term. It really forms the basis for all parties' performance. It is critical to have What I say is the clearly defined scope of coasts of, well, in certain circumstances, the vagueness, wiggle room, and scope can be advantageous, but I tend to err on the side of crisp scope of work. The specificity of the scope of work really directly correlates to the party's liability. In general, contractors should not want to sign a general contract with a broad, open-ended scope, because then the owner could read much further into the provision that was not really intended. Should a conflict arise, the GDC wants those terms to be as narrow and precise as possible, so they're not on the hook for more than they're not more on the hook for what is anticipated and what they thought they were going to be bidding out, because that's going to be trickling down to the subcontractor. If there's ambiguities, the scope of work, the courts will look to the parties in an intent. What is the spirit of nature of the engagement? What were the design call for in the scope of work? Was the bid commensurate with the scope of work to be performed? Scope of work is a very costly piece of litigation because it's very fact intensive, and when fact intensive clauses are disputes, you're dealing with a lot of discovery, a lot of document and exchange, a lot of depositions, a lot of witness testimony, factual interpretation, expert witnesses, things like this. And things of scope of work issues are often avoidable through good contract drafting. So good contract drafting, issue spotting with your contractor and contract raises the question with respect to the scope of work. Well, I think that you've got to fundamentally want to look at what am I being contracted to do. From a GC sub perspective, what is included in this work? What is expressly excluded in the scope of work? Define that clearly, and making sure that's within your purview and that you've priced it accordingly is critical. And those often are required technical questions. And as me as a representative, I can't always answer those questions when I'm putting a contract together. I need to be able to rely on my client's technical interpretation and scope before I can write any counsel in that respect. Sometimes there are rules in a contract and clauses that pertain particularly to ambiguities. How are ambiguities interpreted? How are ambiguities handled with respect to scope? What's the process there? Who is it screwed? Who is it screwed against the contract? Is it construed against an additive change order? What are the ambiguity terms on this contract? And are there any allowances for undetermined quantities or qualities? What things are fluid about a construction project? Quantities and qualities can change, and what are the allowance deviations of scope? Does your contract provide for that? You might want to consider it. What happens if the scope changes or evolves? Again, construction projects are up, they're down, they're left, they're right, they never go according to plan. So sometimes scope evolves, sometimes the owner changes their mind on something, sometimes the building to plans become impractical. You can't sometimes it can't be done. What happens when that evolves, and that what is the liabilities there? I'm going to move on to interpretation of contract documents in the order of precedence. And many different documents often incorporate into a contract. For example, any given construction contract might include the main agreement, the general conditions, the supplementary conditions, exhibits, modifications, specifications, and drawings. So as you can imagine, if the agreement incorporates all of the particular contract documents, you've got a lot of reading to do as a contract party and make sure that all those obligations and incorporated documents. You've also got a lot of reading to do that you are continue compliant with them. as you can imagine, there's a lot of potential for conflict. And one of those very large construction projects that incorporates many different addenda and external agreements. So you want to make sure that, number one, you've laid your eyes on all of them and that you understand them, that you can abide by them, but you also want to understand exactly in insertive provisions the conflict amongst the documents. And lawyers and clients, we're all human, and we're flawed in the way we might put together a contract such that maybe a term conflicts with an existing executed contract, or maybe an issue arises that was unforeseeable that created a contract conflict, in which case hopefully the governing agreement contains an order of commencements that the contracts can be interpreted: main agreement, the general conditions, the supplementaries, then and so on. You just got to establish some type of order of precedence, and that's something you really want to look forward in your construction contract. As a general matter of interpretation, the courts will favor specific of a general terms, and ambiguities are construed against the drafter. So you want to consider that as well as you're putting together agreements. Flow down provisions. Every contract, every project is subcontractor must ask themselves, have I seen or obtained a full copy of all the obligations or contracts that I'm assuming by the flow down provisions? Contrarily, are there flow up provisions as to the duties of the other parties? For example, does the GC assume any risk, and in your scope of work as a subcontractor you don't fully assume or agree to indemnify? Just by nature, flow down provisions generally incorporate the general contract terms into the subcontract terms. So most general contract of good contractors will make sure that the subs are required to abide by terms of the general and the prime contract. Got to look into that. If you're a sub, you got to understand that what those contract means. It's the contractor's way of shifting the risk to make the subs assume the risk that they've accepted, the general's accepted to the prime contract. There's a lot of potential for conflict that causes with multiple contracts, conflict of clauses, ambiguities that we need other parties to interpret that contract. It gets expensive, and it's sometimes, generally it's better to clean it up on the front end. Payment. Payment is perhaps the second most important term after the scope of work. It's an essential term to any contract. If you don't have a price, you don't have a contract. It's really critical, and the basis of payment can vary in the way the contract is facilitated. Within the line items, read out the scope. There's a noted percentage of completion that a cost plus can be reimbursable cost plus overhead plus profit not to exceed the GMP price. The contracts in that scenario will typically define what reimbursable costs are, or perhaps it's a units price and the basis of payment, like requirements contract. For example, paving of all roads in the county for a year. Payment is going to be just generally a process where the lender is going to, the lender is going to issue the payment. It's going to trickle down to the owner or the architect, who then pays the GC and then pays the subs. But the payment application process is one in which that is completely inverse. Work performed by the subs, work performed and then been submitted to the GC, and then the GC submits to the architect. Architect GC submits it by virtue of a payment application. Architect then certifies the work. Typically, will then go straight to the lender. The lender undertakes their own analysis as a construction lender to ensure that the project documentation has been met, the lender risk has been mitigated, and a lot has been issued. There's a lot that gets to be involved. Just to give you an idea of the timing of what occurs in that construction project as the payment. Let's just say that the subcontractor performs work on January 1st. All the subcontractors are going to work, mobilize their workforce. They're going to purchase materials on a matured credit, and they're just going to have to expand all the way to get what they need to do to mobilize up front. And they won't submit their pay app until January 20th on January 20th. So hopefully under that scenario, sometimes they're given 3 weeks, sometimes 4 weeks of work, depending on the terms of the contract and how the pay apps are coordinated. Contractor has 5 days, typically January 25th. They'll submit a pay application to the architect. If they're using an AIA 702, the architect will then certify the draw request and the pay application. The pay application is then submitted to the lender, in which times it's facilitated to well, the owner doesn't pay the GC until around February 10th under a hypothetical. So at this time, the GC in turn doesn't pay the subs until about February 25th. So under this ideal situation, we're looking at 50 plus days, 55 days until the GDC pays the sub. As you can imagine, that's quite crippling for the cash flow of a subcontractor. When you add retainage into that, it doesn't leave much room for subcontractors to have good work, because if there's any offsets, really would cripple cash flow. And cash flow is already crippled, but could cripple financially a subcontractor who's out a lot of money for essentially 2 months of labor, having not been paid one single dollar on the project yet. With payment, you're going to need to, again, issue spotting. When you're putting these contractors together, fundamentally you're going to want to ask, you're going to want to know what must be done and what must be furnished before payment is due. Are there contingencies or risk assumed for the right to payment matures? For example, pay when pays clause, which will go into when is payment due. Are there progress payments? If so, what prompts them? Are there dates? Are there milestone progress? Is it a payment at the end of the scenario? And is your contract going to affirm? Is it going to affirm all these positions and these provisions? Is there retainage? If so, how much? What are the conditions of the payment for the retainage? Are there releases? Are there payment affidavits that need to be furnished before or after payment? How will that exchange work? What are the protocols in the procedures for ensuring that the releases and the pay apps are submitted? Is the payment subject for approval by someone? I just went through the process where a typical large project where an architect got certified off, but is there perhaps someone else that might be involved in that? If you're unpaid, how do you suspend or terminate work? What's that protocol? What's the noticing guidelines there? What can you do to suspend work for and not make a material breach? What obligations do you have if you are paid? Are there certain things you must do? What are the procedures? So payment is really critical. I mentioned the 702, which is used in the payment application. A pay-up on the GMP contract is consensus document 291. 292 is for a lump sum project or a lump sum contract. If you're using a schedule of values, the consensus documents utilize the 293. With the 702, let's just say you have a contract and there's a requirement for a pay application. The pay application is an AI document 702, and it will generally for the contractors to have the contractors apply for the commitment and the architects for certifying the payment. So it includes specific information including total dollar amount of the work completed, the retainage, the total payments due to date, a summary of change orders, and the current specific payment that is requested. You can go to the AIA website and they'll have all the forms available pertinent to this, but it's important to note that in the pay application, the contractor is certifying several things, such as the completion of the work and financial accuracy of the application. And pay applications are handed out to an affidavit. The Delta Fire sprinkler case, for an example, it's one that stands for the proposition that pay applications can be used against the contractor as the certification of progress and payment due. Used against the lien context as well. The form of certification, the SWORD certifications. Construction contracts, move it along to payment section, the many risk shifting provisions, and one such mechanism, paid when paid provision, requires a payment for one party before there's any other requirement to pay the other party. Typically, there's a contract provision is found in the contract between the general and the sub, and it shifts the responsibility. It shifts the risk of payment to the subcontractors, and essentially saying, you sub me the contractor, you sub until I'm paid from the owner. It shifts the risk of owner payment to the sub, and if you're a sub, you should think twice about signing these. Courts tend to disfavor them, but the clauses itself must clearly shift the risk of payment from the contractor to the sub. You can't have any contractual ambiguities in the circumstance, and I'll give you a couple examples. As the starting point, the burden of drafting a clear and unambiguous pay when paid provision is on the general contractor. If the pay when paid provision is ambiguous, it will not give you the desired effect, and it will result in a general contractor be required to pay the sub within a reasonable amount of time. The next factor pertaining to enforceability of pay when paid provision is whether the subcontractor incorporates the subject of the prime contract. It's not the next factor, but it's the next thing you want to look at because it pertains to the next factor, which is ensuring that there's no contractual or ambiguities and that the provisions, paid when paid provision, is clear and unambiguous on its face. So if the prime contract is incorporated into the subcontract, they require specifically that, here's a specific example, some prime contracts require the GCs require affidavit for payment certifying that it's paid all its subs before the owner actually tenders payment on the project. If the prime contract is incorporated with the subcontract, as you can see, it has the subcontract pay when paid provision. As you can imagine, it pays a contractual ambiguity which may nullify the pay when paid provision. So if you're you're on the drafting side in favor of the GC, make sure that you've dealt with that issue in your contract. If you're a sub, just avoid signing any contracts with paid when paid if you can, if you have the business leverage to do so. The general paid when paid provision has to be clear. It has a specific, clear expression of the owner to the general as a explicit payment to the sub via them, which is in the progress of the final payments. They are enforceable. Courts are split, whether they're split nationwide. I've got a list of states that are ruled contract with pay when paid clauses. It is Arizona, Colorado, Georgia, Florida, Illinois, Maryland. Contracts here have abolished the paid when paid clause, but in other states the paid when paid clause and courts have tended to invalidate them. The following states have opposed that: Alabama, Connecticut, Massachusetts, Pennsylvania, Massachusetts, and Washington, D.C. And the Forest Service has also invalidated the public policy disfavoring anti-labor provisions. The burden of clear expression is on the contractor. Specific citation: Everett Painting versus Vajorth Construction. Citing, quote, the intent in most subcontracts, the risk of non-payment does not fall within the subcontractor, and if parties do intend to shift the risk to the subcontract, the contract must unambiguously further the burden of expression of the general contractor. So to keep in mind when you're dealing with those type of provisions, the example of a clause as enforced as a contingent of the clause. There's an example of a contingent clause that was not meant as the example. Ross Plumbing and Heating versus this is a second district case. Final payment inclusive of the payment must be paid within 30 days of the completion of a construction project. Acceptance of the same by the owner as a condition precedent. Receipt of final precedent of the final contract of the owner. It's a pretty clear and unambiguous shifting the way it was going and where it was going to. There's an example of what's not the pay when paid extension clause. Under no circumstances will the owner pay the subcontractor until funds have been advanced by the owner. And that's the Sharp versus Macri case. And that's the second district case. You can see the Bentley Construction Engineering case versus Allphase versus Electric Mason's case. If you want a better example, if you want to compare it to each other, there's clear specificity in the first one, as the second one not so clear. It's a little more loose. It doesn't shift the burden like pay when pays are required to. Now there's an equitable defense to paid when paid clause. That's equitable defenses that a contractor must attempt to collect from the owner in good faith. So just because a pay when paid clause is in a contract, it doesn't necessarily invalidate the whole contract. It could be that it's a litigated issue as to the efforts undertaken by the contractor, whether they're reasonable or if they're in good faith, and it's something to consider. It's not the be-all and end-all. Another thing to consider is just because the pay when paid provision exists, it doesn't necessarily depreciate the lien rights. You may probably, I know you do here, or at least used to, you may have the right to affect the lien and pursue the security instrument from the owner if they have not paid. If there's another issue that pertains to the owner, there's a final payment affidavit. I mentioned previously what it entails, but it's going to require a certification that the lieners have been paid in full. Sure, the liener for anyone who has not been paid in full. The owner may ask for part of this as it is part of the contract administration. When you're putting contracts together, understanding what the pay app you're using and what the requirements are is pretty important to administering payment. So, talking about change orders and liquidated damages. Change orders are most contractors are to require written change orders in contracts because you don't want loosey-goosey job site constructions governing your contract. You want to articulate your contract, who has the authority to sign the change orders, under what circumstances change orders will occur, specifically address all the issues pertinent thereto. Think of change orders as mini contracts within a contract, because what it's doing is it's expanding the scope for a particular price. All change orders are enforceable if the course of the contract provides it, and even if the contract doesn't provide it, if you can establish a course of dealing that says that the site project, the contractor accepted all change orders 100 times, and whether you to disavow the 101st is unreasonable unless it's between the parties. I think that you need to document it still internally, document some type of written record. I wouldn't risk it if I was overseeing a construction project. There's an order which these things are enforceable, but they're hardly ever enforceable, especially here. And in respect to the change orders, what you want to know, the scope of work, is it adequately defined to minimize the disputes of what is going to be extra? Are there notice requirements for change orders for that extra work? Are there requirements for written authorizations, or what are those requirements? Who's the signatory? Who has to prepare the change orders? What is the form in which you prepare them? Must the owner be a signatory to the change orders, or is the contractor itself granted its discretion? What's the architect's rule on that? Have you made sure that, if you can, make sure that the dealing, say that there is no course of dealing. If you want to hold your contractors to it, you want to make sure that the change order procedures and protocols are not ambiguous. When must it be signed, before or after the work? And that's a pretty critical component. If it has to be signed before the work and it wasn't, it could affect the validity of the change order. As a sub and as a laborer, as a supplier, as a sub, and the contractor, are you preserving the lien rights property when you're administering the contract? On a change order, are you not releasing the accidentally? And don't forget that the change order has a mini contract. You now are revisiting the contract analysis where you have to define your scope. You have to get your court terms in there for price, things like that. What does the contract require? In terms of that process, you might want to address that as well. Liquidated damages. This is something to be careful of. Keep the eye on the timing. Document delays in respect to liquidated damages. Communication is key. Liquidated damages can really add up in a contract, in a construction project, because inevitably they get delayed and off schedule. So what does the contract provide for the liquidated damages? Are they something that are be implemented and utilized as a penalty? If so, they're not going to be enforceable. Were they pertinent to damages that are easily calculatable in entry into the contract? If so, they're not going to be enforceable as well. So there's certain provisions that pertain to the enforcement of a liquidated damages clause. So you want to be prepared for addressing those in your upfront contracting and deconstructing contract on the back end. Make sure that you have a counter argument to that. They can't be unconscionable. You can't also, with LDs, you can't, with actual damage, you can't get both. It's only one or the other. So what's it going to be? Just as some things for you to think of when you're putting your contracts together as LDs. What's the rate of liquidated damages, and how do they relate to anticipated actual damages? Is there a different liquidated damage rate for the delayed and substantial completion versus final completion? What's the corresponding bonus for early completion? Are there liquidated damages available for delay? Are those in lieu of actual damages? You want to go through that process. Touching on retainage, that's something that is part of the payment process as well. Retainage is part of the portion of the agreed upon price that is deliberately withheld from the work until the work is substantially complete to help that the contractor or the sub actually completes the work and satisfy the obligation of the contract. It provides the incentive for the party to perform as it pertains to 10%. 10% is usually the 10% is the industry standard. Sometimes there are differing situations where the 50% completion of the project has been achieved. It might be 5% for the rest of the project, but I know that there's some specific limitations on retainage of public work projects that you'll need to be aware of in respective jurisdictions. Retainage conceptually or historically, the 1940s English railways projects, wherein there was a flood in the market of all these underqualified, undercapitalized contractors, and contractors began withholding 20% at the time because that was the profit margin on the notion that these subcontractors could not fulfill or having a hard time fulfilling their contract requirements because they were undercapitalized or they were underperformers, etc. And it created this risk shifting from the contractor to the owner, put a little bit to the subs. I think that very much part of the construction culture here today, and again, it provides that incentive for the subcontractor to complete well, and it provides the security for the owner against the liens claimed on the project, default under the contract as the contract nears to completion. It's ripe for abuse. As you can imagine, contractors tend to imagine a lot of retainage from the subs, then they're actually being withheld from their owners. There's not a lot of leverage for subs in ensuring there's no abuse on retainage. Retainage is going to be set forth in the contract. If it's not set forth in your contract, it doesn't exist. It certainly is applicable to subcontractors as far as prime contracts. Again, the amount of structure varies on a case-by-case basis, but some substantial completion is typically going to be a trigger point for a retainage point when it's due. Substantial completion is a common law defined term that is usually when you can occupy a structure or when a CO. There are some alternatives to retainage, such as keeping items in trust or giving the contractor an ability to use retainage, such as having a trustee and investor under management. I'm going to move on to timely performances of delay. No damages for delay clause. Timely performance is something I want to set forth in the agreement. Then you want to understand the effect of no damages for direct causes, so you can write them in depending on which side that you're on. Time is of the essence when it makes its way into a contract. Means that if time metrics are failed to be complied with, it constitutes as a material breach of the contract. You want to, with respect to timeliness, it's always important to understand what are the notice requirements for time extensions. Are there any requirements? What is the compensable delay? And what are those liquidated damages may come into play? You want to make sure that there's delay components tied into something that is reasonable under the circumstances, but minimally you need to understand what the timing of everything is. When's your delivery date? What's compensable? What if you're delayed and you can't move on as a sub or a contractor and you can't move on to the next project? what's the owner's delay? Let's say building a hotel, you can't put occupants into the hotel, so there can be double sides on delay clauses, and understanding how this worked and is important for any practitioner. There can be no damages for delay clauses, and that means if it goes over project, then you're just analyzing the material breach nature, and perhaps even mitigated by a waiver of concept of consensual point damages in your clause. But I would tell you that there are exceptions to enforceability of even no damages for delay clauses, specifically if there's fraud, if there's willful concealment, or if there's active interference. And if there's willful concealment on site conditions or certain issues that maybe hinders the progression of the project, active interference is a big one. It's often litigated in construction contracts where you got no results, and the owner is simply wants to micromanage the project. Sometimes that micromanagement transcends into a state amount to owner interference, which then has all sorts of negative effects onto the interpretation of the contract. Delay issues can be very complicated and expensive to litigate. If your contract has delayed revisions, you need to get a construction lawyer, because it could get very costly very quick. I could give you an entire spiel on preserving what I gotta say. Moving on, indemnification is a risk and shifting provision. The concept is that it holds the most harmless. States differ in limits of these provisions. Indemnification somewhat cited in materials. You want to ensure that indemnity, and writing indemnification provisions, you want to ensure that the indemnity and the duty to defend obligations are in separate clauses, just in case one is stricken down. And indemnitors are responsible for the losses and costs of defense suffered by indemnities. So you want to make sure that if you're a general and your subs are constructing their project negligently or this sufficiently covers the liability of the subs. From anybody's standpoint, analyzing the indemnity, you need to understand who's going to indemnify, under what circumstances, for what amounts, what's the limits on that, what triggers indemnity. Will you be obligated to indemnify the other party for their own negligence? You shouldn't, but you don't want to look at that. Is there a duty to defend if the other party is at fault? You want to confirm that the limits in your contract are pertaining to indemnity are statutorily and commercially reasonable. And you really want to understand the risks that are to be indemnified. This is a very expensive mistake to make by having a broad indemnity clause. You want to know the property damage to the owner or others from your work, bodily injury coverage caused to others from your work, to cost of defense, or economic loss, owner delays, etc. How broad is that scope to understanding within your indemnity provisions is key. Like anything else, what's the notice protocol to the indemnity? If you don't follow them, is it going to be strictly construed against you? Can you dispute indemnity? Can you dispute the notice protocols? One that I've seen that comes up a lot in my representation: who has the right to choose counsel in defense? Oftentimes, the client will suddenly defect. The issue is being accused of something that they didn't do, and now all of a sudden they have to work with a new lawyer because that's insurance cancel. So now what is that extent going to be covered? And that's something that has to be ironed out in their policy terms. So the additionally named of insured, this is a heavy litigated issue. If you are a sub It didn't used to be, but it is now since the downturn. If you're a sub and you're required to name another contract that's additionally insured, get with an attorney or agent and see if the policy adjustment is made, Mosquito. If that alters the policy term. Certificate of insurance, just by way of education, the additional name and insured employee are employed by the contractor to downstream subs and so forth. They're often a requirement of the prime contract, and they require the liabilities of caused by one person want to be covered by virtue of having additionally insured. Think of one thing, point order, which I've seen a decent amount. Certificates of insurance will be rendered, but somehow along the way, no endorsement, no rider, no amendment was actually made to the insurance contract itself. And if that happens, the coverage will not be triggered and the additional insured will not be covered as they intended to, which has a lot of implications from liability standpoint, but not limited to the bridge of the contract. Moving on to notice. Pay attention to the dates and follow them. You can be potentially excused if you don't. Written notices often require for various situations, including breach, unforeseen or different site conditions. Contracts can conflicts, or you can initiate an AA document with a dispute document resolution. There are exceptions to written notices, contracts. They're typically in circumstances where the party against him starting to notice the defense is more constructive notice of the issue, or there's been a waiver, often through the course of dealing. If noticing has occurred, certain defense has occurred, and multiple times that noticing wasn't required yet performance was effectuated. Notice might be waived through forcibility. Termination. Termination is a clause that there's two types of termination provisions: termination for convenience, termination for cause. Cause is typically exercised by the owner, and there needs to be some relief, or it needs to be addressed in your contract. For cause, you need to have typical conditions which might merit owner cause and which might merit contractor cause. Either way, make sure as you're planning a marriage, you're planning a divorce, termination is always included and addressed, and that is important to know what the parties' rights are. You want to be asking yourself as you're drafting these documents, are there stated reasons what prevents beyond material breach? What are the notices, the common themes, what are the notice requirements? Do I need to send notice to the sure team? Do I need to send notices to the lender? Are there any conditions precedent to termination, to sub? And I need to provide notice to the contractor. Do I need to give the independent decision maker an opportunity to come in and resolve the conflict? Is there a care provision? You want to know if there's a cure. So you notice the default and you want to know what's the responsibility of the cure. Once the contract is terminated, what is the stated rights and responsibility? What do you have to do to wine and dine the contract? Do you have an obligation to mitigate? Certainly in common law you have an obligation to mitigate your obligations. You want to know in the contract if it's determined what's your litigated obligations. If you want to, if you have determination for convenience provisions in your contract, is there a good faith requirement? What does that entail and how is that defined? Are there conditions precedent to any other benefit? Do you have to do anything else to get that? Who and what is compensable? Let's say it's terminated for convenience. Well, what does that mean for the contractors? Obviously, they bid out this project and they have probably turn down other projects. So the consequences of the outages are available for contractors or have been terminated for convenience. What are the duties of the technical components of the transferring or release of pertinent if there's been a determination of termination, which are prospect. A couple more items. You want to understand dispute of the resolution contract. I mentioned the termination clauses, but say there's a dispute. Does your contract have that IDM, the architect, the independent decision maker, who makes the interim decision to claims disputes? If it's AIA, usually a pre-mediation is a condition precedent for moving forward. Resolution mechanism, and the AIA contracts are new forms, or you check the box when you're executing the contract and you're either choosing whether it's arbitration or litigation. I'd much prefer being litigation and could write a book on why, but I'm not going to bore you with that solicitation now. Attorney's fees. Plain and simple, attorney's fees are only given by statute or contract. Consider your facts when you are determining whether to include them. Are you in a position of power? Are you in a position where you can, if you have a dispute, you can bleed the other party through, force them through, pay an attorney with any chance of recovering the fees without negotiating? You want to know if the other party is litigious. You want to know if their background is. If they're litigious, you might want to have a preview of the attorney's fees, or it could swing the other way, or maybe you won't have one in there. Think about that one. There's going to be some issues in there before you blanketly push an attorney's fee provision into your contract. I'd say more often than not include one. That's my personal preference, but at any rate, it's always finalized on a case-by-case basis. Does the attorney's fee always, when you are putting a provision in there, are they always prevailing party, or do you want to put a provision in there that includes attorney's fees for indemnifying a defending issue? You want to put limitations on the fees. The fee is up to a certain amount. Fees on appeal, fees, litigating fees, that's something that comes up. You can lose that notion, move for fees and ask for fees, litigating whether you are entitled to fees, and they decline your fees on that. So now you can write in every contract, which I would prefer, which I'm entitled for prevailing parties fees, fees for fees, fees incurred for trying to get fees. It's important to note that a recent decision, but I think it deviates by jurisdiction, but in Florida there's a Tritech versus Gale decision, which was on a construction dispute on a construction lien, but the court came down and said, yes, the prevailing parties are entitled to attorney's fees under the statute, the lien statute, but based on whoever wins on the significant issues of the case, we don't have to determine who is the prevailing parties on any given case. So instead of a net judgment rule where when I win $1 and you win $0 from the prevailing party, and I win on 3 counts and you win on 2 counts, I'm the big winner because I won on the significant issues. We're going to say, you know what, there was no winner on the prevailing party on that. For better for worse, that's a law here, and there might be similar law in your jurisdiction, but that's the conclusion of the construction contracts. And I hope you found the value of the key provisions, the key considerations I had to say. And by no means is this all inclusive, but if you think anything else, get your brainstorming and give you something to think about as you're putting pen to paper and documenting these construction contracts. Again, Franklin Nolan. Feel free to contact me, frankienolan.com, regarding the presentation, or frankienolan@gmail.com. I'm at 775-203-6497. Follow the email address, or you can follow any other associated associated with this group. And feel free to look me up on the web. Thank you for your attention and best of luck.